Welcome to the Bold Inventor Show. I'm JD Huebner with my trusty co-host, Matt Kolseth.
Hello, hello, hello.
And I want to talk about the 4 pillars of patentability as one of our kickoff topics. Before I get to this, I want to drop a quick link as well to this on our website under resources. The blog is about the 4 pillars. And I wrote this initially back in 2022, just refreshed it. So basically, hey, what do you need? What do you need to get a patent? And it really comes down to 4 things on the utility side. So the first pillar is novelty. Novelty. Okay. So novelty is the first one. First pillar.
And you don't mean like novelty gifts, I take it.
I don't mean novelty gifts. That's a great question. No, We're not talking about necessarily that, but hey, some of these inventions
novelty gifts could be novel.
Yeah. So first pillar is novelty. What does that mean? Novelty means it must be new. Brand new. It is true. To get a patent, you have to be the first one to file it. You may not even be the first to invent, but it is a race to file it. Okay, the U.S. joined that system about 10 years ago, so it must be first. And so it's the first time in history. Sometimes we'll get this question like, "Hey, I want to patent something, and the patent it expired. It was patented in China and it expired 20 years ago, but it's never been patented in the U.S. Can I file it here?" Well, no, because it's not new, right? It was been published and known by those in the field before and up to now, or anytime in the past. And those patent examiners love citing really old, like ancient publications. The older, the better for them. I'll never forget one of the early applications. We had a new fan that we were seeking a patent claim on, and the examiner cited a washing machine from 1890, like some old, like you guys we're going to shut you down so hard. You're not even in the 19th century.
Yeah, oxen powered dishwasher, washing machine,
Yeah. Sorry, Mr. Inventor, you're 100 years late. So that's the first pillar. It must be new in the world. Second pillar, this is a mouthful, and I'm glad we have Kendon on to help me. Non-obviousness, and I'm including the hyphen on this one. I've seen it with, I've seen it without. Non-obviousness. Okay, so let's just take the obvious word obvious. That means obvious. It means that, hey, even if someone hasn't ever done it before, right? You've met the first pillar. If it would have been obvious to just try another color, or another flavor, or adding another chemical, or putting a certain widget together, if there was writings or knowledge in that field that you could put them together, and for some reason no one has ever done it, you might meet the first pillar but fail the second. And examiners will combine lots of different pieces. They'll say, well, here's a piece of prior art. Here's a piece from the history, from existing technology. And here's another one from a long time ago or from present day. And it wasn't even a patent. It was just a publication in a journal. And you put these together because they would have been obvious to put these together, right? Tunnels and lights, lights in a tunnel, a lit tunnel would have been probably obvious because it's dark. So they'll make the argument and you could come back and either amend your claims or fight with the examiner. Third pillar, it's utility. So I'm going backwards now. This is on the utility patents only. Design patents obviously don't need utility. This is a requirement. So you've gone through the hard stuff. It's new, it's not obvious, has to have some benefit. Okay, utility is a very low bar. And you've got to be able to provide through your writings, your specification, or your drawings that there's a benefit. There's something happening, some unique actual things moving, right? That you can put into motion with current day technology, right? You actually could benefit from it.
You once told me that the bar to novelty is so low that even if something is humorous, it can be registered as a patent potentially.
Well, the bar to utility, yes, is so low. Yeah. Being entertainment, right? One of the funniest examples from my patent law class, going back almost 10 years, is the granted patent on the method of entertaining a cat with a laser light. Okay, genius. That is patented method. Now, whether that would be valid under the current, Alice law is yet to be seen. But that's a granted patent, right? So there's some benefit. Somebody somewhere is entertained by it. There's some issues come up where, hey, you can't actually prove that this does what you say it does. Perpetual motion machines is super classic for really not having utility. And so when there is a question, the examiners will say, you know what? You need to prove it. Bring your invention in and show it off. And inevitably, none of the perpetual motion machines have ever made it, okay? But it's one of the most popular examples of failing utility. So that's section 101. Okay, you've been waiting for it. The fourth pillar. You need all four. And I'm gonna go find one. Okay, eligible. Well, this was, I kind of snuck this one in. Eligible.
I would have missed this one.
This is under section 101 as well. Again, my spelling, I'm not confident. Eligible, there it is. This means that it fits. There's four main types of patents you can get: machines, compositions of matter, processes or methods, and assemblies. All right. So four big categories, almost everything. What's that?
Don't forget plants.
Plants aren't
they their own category?
So we're talking about utility patents today, Matt. We'll talk about plant patents another day. There are plant patents for things, as you know, like Dole or Monsanto. They've got pineapples, different fruits and flowers, whole different kind of organic botanical description.
Got it. A whole different category, types of patents. Got it.
Absolutely, different category, but that you still need to be eligible. Right? It has to be composition matter, it has to be novel, it has to be non-obvious, it has to have some utility or benefit, which can even be different coloration. Sticking with our utility example here, eligibility has to follow the rules that have been sort of passed down through the Supreme Court. Alice versus CLS Bank was the first to kind of say, you know what, you're just doing human activity on the computer and denied, not eligible. Other kind of more classic examples of things that are not eligible are natural phenomena, right? Gravity. Whoa, how's the pen falling, right? Or if there's, equations, right? E equals MC squares. E equals MC squared. Laws of physics, laws of nature. Those can't be patented, right? That can't be patented. It's just it's just the way things are. And then trying to patent human activity alone without transforming, improving, making things more efficient, adding some technological component is not going to be eligible. So that's the essence. Those four pillars, and you, sir, will have a patent. I did mention quickly, there's another area of patent called design patents, where you just need three. You don't need to have utility, but they've got that unique shape, the three-dimensional shape, right? That must be first of its kind, new, and can't be an obvious design, and must also have eligibility, but does not need to have any functionality. No utility required to get a design patent granted.